All right, well, thank you all so much for coming to this month's alumni series. Super excited to have Jenny here to talk about careers in intellectual property, specifically as a patent agent. Jenny May flew in just for the day today to come to this seminar, so like major snaps for the event. And yeah, I will turn it over for her really quick before I do that. There is going to be a sign-up sheet that I will pass around. So you just write your name on it, and that's it. So with that, I will pass it off to you.
Okay. Well, thank you everybody for coming to my talk. I'm very excited to be here. I feel like I'm giving the seminar that I wish I had when I was a grad student, interested in possibly going into IP. So science, strategy, and intellectual property. That is the crossroads upon which this career path sits. Disclaimer slide. A, I'm not a lawyer. Also, the views expressed here are just for the presentation of my personal views. They don't reflect the views or opinions of Diane Morris or Ed's clients. Okay, so for an overview, we're going to do an introduction to me and my career progression, how I got here. Then we're going to talk about the different career paths in IP, including the different entities there are, what the different titles mean, what the patent bar is, requirements for it, how to study for it, give you a vignette into the life, the day-to-day life, give you some practical advice, and then we'll be doing it. So my personal career trajectory, I was a biochemistry undergraduate at the University of Washington. I did my first research experience with Rita Toda in the Department of Medicinal Chemistry. And then I did a lab technician position in the nanopore sequencing lab, so pioneering sequencing lab under Jens Gundelof at UW. And then I did a postdoc research program as a fellow in the same laboratory. And then I came here for grad school. I did my graduate work with Dr. Mayumi Fujita, who is now non-specialist in the Department of Dermatology. And I have a couple of mentors in the audience that I'm very happy that are here. So presenting. I then did a scientist position, curation, data science curation position at Rancho Biosciences, which was fully remote. And then I pivoted into patent law at Diane Morris. I started as a technical advisor and am now a registered patent agent. So for going from the village to data science, then to IP, the existential crisis of being a PhD candidate and knowing that what I wanted to do originally is no longer what I wanted to do. So what do I do now? When I graduated in 2020, that was the height of the pandemic. I graduated on Zoom and my funding was not quite there anymore. So the postdoc I was thinking about doing as a tide over wasn't available. We were also still one person in lab at all times. So I couldn't do that. I was thinking maybe I want to do science writing, then patent law, what things make me happy that would also allow me to progress in a career, thinking a lot about it. So one of the things I did go to in considering between science writing and patent law was attending the American Medical Writers Association conference, I think in 2020, and talked to mentors there, did informational interviews, try to understand what it was that medical writers do, and realized that I might be siloed into writing the same kind of content over and over and over and over again, and I didn't want to do that. So I also then talked to folks that through connections through SACNAS, with Carlos Catalano introducing me to one of the grad students from UW that he mentored, who was a full patent attorney at that point. So I was able to talk to him. His name is John Chapman. And he was very insightful in telling me what it was like to be a patent attorney, what it was to come from this background and to pivot, and what skills were necessary and why it might be a good fit for me. So that was really, really critical. And at the time too, I was still active in AIA here at campus. So, getting exposure to other biotech startups and other opportunities was great. but I realized like I didn't want to be benchside anymore. So I missed writing. I missed still having diversity of breadth of experience in applying my different skills from different parts of my life to something. And so it kind of led me to data science first through my connections, and then to IP, which is where I am. So intellectual property terminology soup, because there's a lot of terms. Some of the common questions that I got and still continue to get are, what are the different entities that there are? Careers in IP, like what are they, like tech transfer offices? What is it? What is it like being a big firm? What is a big firm? What's a boutique? All of those things. And the other question I get is, what are the differences between the different IP positions, like a tech advisor, patent agent, or a patent attorney? So we're going to get into that. And we'll start first with the entities. So the USPTO, the US Patent and Trademark Office, they are the gateholders to our intellectual property in the United States. Their mission is to drive innovation, drive global competitiveness for the benefit of Americans. It also is the body that grants patents for inventions and registers trademarks. On that end, the patent examiners, which are the counterpart to the private practice of IP, that's the public practice side. So patent examiners are the ones who are serving to look at and examine an invention and determine how it's new and what is actually patentable in something, some application that has come across the office. Tech transfer offices, all universities have them. A core legal role of them is to ensure that there's proper protection for intellectual property that comes out of campus. They also are the ones facilitating, license agreements, NDAs, material transfer agreements, other partnerships, and other contracts. That is intellectual property at a university, through your tech transfer offices. And I believe we still have an internship here program for IP, people that cares for IP in the TTO here. I did not get to participate in it, but I would have liked to. I found out about it too late. And then there's companies, right? We're at a medical campus. Everyone is adjacent to pharma, big biotech. So there is IP counsel, tons of IP, of course. But IP counsel at those companies, those are in-house positions, like lawyers hold those, patent agents can be in those. But they, their goal is to implement and oversee the way that companies' global intellectual property strategy and portfolio grow and are protected, really. They look at mitigating any competitive threats. They also lead looking at mergers, acquisitions, collaborations, licensing, kind of the same way TTOs do, but that's for a company, right? So those are those three. There's also patent boutiques and big law. I'm in big law. I did have a very short internship at a patent boutique, and we're going to talk a little bit about those differences. So a patent boutique is a small law firm. They're focused usually on specific niches in the industry based on who is part of that firm, which partners, and what their subject matter expertise happens to be. They also tend to be pretty small, pretty much no more than 30 to 50. Some of them can get up to 100, but really once you start getting much bigger than that, you're getting to big law. And they are considered a really specialized IP service provider. In contrast, big law is, that refers to the very large firms of hundreds to thousands of attorneys. When I joined Morris, it was around 700 attorneys across the different offices all over the world. We're now, I think as of last year, at about 900 something. I haven't heard the numbers yet for this year, but we might have crossed the 1,000 threshold. I'm not sure. And we are, I believe, in the either 50 or it's anyway. It's there's rankings for the American law firms and their sizes and what they offer. And big law refers to those usually 100 to 200. It also is that one of the big differences is that big law is a full service firm. So they're not just doing IP, they're doing law across all the different aspects of just all different aspects of law. So it's a one-stop shop for literally everything. So copyrights, trademarks and stuff, that's all IP. You can do M&As and corporate, many other immigration. So Big Law has all of patent boutique and more. It's the bigger entity. Okay, so we'll switch over now to the titles. We talked a little bit about the patent examiners. They characterize themselves as you must be a STEM professional, at least from what I saw on their site. But it is true, like many patent examiners, you have to have either an engineering background or hard science background. They also can take the patent registration exam, which eventually, if you practice as an examiner first, you can, under certain circumstances, waive the exam and practice outside of, after you're finished being a patent examiner, you can then be a patent agent elsewhere after finishing your service as a patent examiner. And some people do that. I found that a lot of people like to say once they're patent examiner, it's nice to be comfortable in a system where you're going to continue to go up in your GS level. And it seems like people that are there are pretty happy that I've met. In terms of starting, pay scales and stuff, these are public. The GS system is public. So those with bachelors, like the engineers that are patent examiners, start usually GS 7 to 9, depending on the experience. But if you're a PhD, you would start higher. So GS 9 to 11, depending on how much experience you have. And then getting into private practice, tech advisors, technical specialists, patent engineers, non-lawyer, clearly. We work on patent prosecution, so drafting and prosecuting patents, but as a tech advisor, you are not registered with the USPTO. You have to take a patent bar. You cannot sign anything. You must work under the supervision of a patent agent or attorney. As a patent agent, which is the next step from the technical advisor, is still prosecution, but now you're registered to practice before the USPTO. So you've passed the patent exam, and there's a mandatory 45-day review period that follows passing the exam, and that's for a character assessment. And we can talk about that more later. And that here, at that step, you can actually independently represent clients specifically at the USPTO, but not state or federal, or that's a lawyer's realm. So, and then the terminal step for this career path would be the patent attorney. That's lawyer. So you've gone to law school, you get your JD. You can still do patent prosecution, but you can then do things like litigation. You can render legal advice, opinions. You can do negotiations, drafting license agreements, and other things like that. So your capacities are very different once you become a lawyer. Okay, so just general career trajectory for like the pathways. For the typical route, I think a lot of people, like engineers, will take this route. They'll get a bachelor's, optional grad school, and we'll talk more about that in a minute. If you don't go to grad school and you are an engineer or a scientist, you can go straight to law school. You would take your bar exams to become barred as a lawyer, and you can also then take your patent bar. So a little bit of timing for rough timings for studying for said parts, according to. And here you would have up to 8.5 years of post-bac study to get to that position, and that's with 0 experience. On the other hand, so if you did grad school, and then you then work as a tech advisor, and study then for the patent bar before doing part-time law school, the timing differs from when you become a lawyer, but you would gain experience in industry already at 5.5 years for the same amount of time. So I started out as a tech advisor, and I'm going to cover both tech advisor and patent agent. They're very much the same. It's just that I can sign my stuff now. So what is this job? Does it mean? What do we do? And what can I not do? Which we're going to stress a lot. So as a subject matter expert in SME on the technical area, You advise and support attorney work, utilizing that experience in that technical area. We primarily do patent prosecution, so drafting and prosecuting patents, like preparing office action responses, and then you can also do diligence tasks, but everything you do is under the supervision of an agent or an attorney, not sign off on your work products or represent anyone. For general experience, wanted to share some of this for when I started. New hires are typically assigned a mentor with a similar technical background, if possible. Your mentors provide work to you, support with you, give you the face-to-face training. You get that also from other patent agents, senior legal staff, other attorneys and firms. You're doing patent prosecution. So a couple of these at the bottom that fall within that group. Patent agent, what's different? As a patent agent, I'm registered to practice before the USPTO. I have an official registration number. Again, still doing the same things, still in the supervision of my attorneys, but I can, if you know, they can't sign for something for whatever reason, or if I were to leave and be my own practitioner, I could sign my own work products and then represent a client before the USPTO. But I cannot provide legal advice as I am not a lawyer. I'm a mere scientist, but I'm a patent agent. I can't provide legal advice. So journal experience on that side, it's continued mentorship from the attorneys in firm. My mentors, my attorneys are the internal clients. They again provide that work, the support, the face-to-face training. All of that is all, it's all the same continued growth. So it's just continuing along the path towards becoming a patent attorney. Let's see. So additional tasks that I do actually. Oh, so the patent bar. So many questions about the patent bar from many people, especially for information. So what is it? Do you need a law degree? Here we go. So the patent bar is a colloquial name for the United States Patent Registration Exam. It's 100 questions, multiple choice. It's open book. It's taken in one day, split in half, 50 questions for the first half, first 3 hours, lunch break, 3 hours, another 50 questions. You can take it year round because we do it through Prometric now. Before said modern time where you could do it through Prometric, you could do the exam in person at Alexandria. I don't know that they offer that anymore. And it's now a choice. It didn't used to be that way. So who's qualified to sit before that exam? There's different eligibility schedules for the qualifications, but basically all engineering disciplines and hard science disciplines, weirdly excluding math, which doesn't make sense to me, are included in Schedule A. So if your undergraduate degree is in that category, you already qualify. So as a bachelor, you could have taken this exam. If you did not have a hard science or engineering background, and have not done a PhD, you would be able to qualify if you had enough credits, enough coursework under your belt to satisfy a different eligibility schedule. However, for the people in the room that are postdocs or current grad students, if you have an undergrad degree already in science, you're good. If you're doing a PhD, you're good. So Schedule A is likely what you would do. They check it. The Office of Enrollment Discipline. Sorry, I was going to say illegally. Enrollment and Discipline, the OED checks that. They check the transcripts. And that's before you actually register. You have to apply to take the exam. They check your eligibility, and then they give you the green light to then schedule your exam. So there is a wait time between that. But they do verify that, and hopefully in the next 2 months. But no law degree required, no law experience required. That's not the goal there. So multiple choice and open book sounds really easy. That's really deceiving. So I'm going to talk about that studying and the timeline. So the pass rate for the exam was 46% last year. Honestly, it sounds close to 50, but it's a very, very hard exam. It's very difficult. It requires dedicated study time to prepare for it. By open book, it means you can look up things from the Manual of Patent Examination Procedure, which is the MPEP, or student statutes, which are provided when you take the exam. It's on your computer. However, you will definitely not have time to look up everything. You want to know where to look for your answers if you're double checking yourself, but you will not have time. It eats time to look it up, so you want to have as much of that under your belt before you take it as possible. As for studying, most people that are at firms use PLS course. It's like the gold standard. People basically all use it or materials from it. You can self-study with MPAP. That's what you're all to do. You can also find old exams, which would be helpful, but yeah, again, most people use PLI. So I would say if you're pre-quals, it's a great time to study for it because you're still in test-taking readiness. When I took the exam, I was probably close to like 6 to 8 years over, like past the time that I actually had last taken any sort of exam. So that was hard. And so it's helpful to be in test-taking readiness. If you're not pre-quals, the next best time is now. Patent lingo it's like trying to learn a different discipline, science and jargon in them. It takes you a little while to do, totally doable. You will get the concepts, it will happen, but it's gonna take time. So the next best time to start is now. So what happens when you pass though? When you pass, your name gets published in the USPTO's Gazette, and it begins this 45-day open comment period to complete your character fitness assessment. So that open waiting period is anyone can submit comments regarding your moral fitness or character to be someone able to represent somebody at the USPTO. That usually will just pass. You know, if you're not criminal or something, either it happened, or you should disclose it. But after that comment period closes, the USPTO's Office of Enrollment Discipline, so that we will complete processing of your application to practice and will eventually issue you a registration number. And then, and only then, can you hold yourself out as a patent agent. Without that number, you cannot do it. Like if you pass, like that's great. Wait till you get your patent registration number before you say that you're a patent agent. You don't want to put yourself out there as that before it happens. So don't think about it. Okay, so that's the patent part. Jumping into a vignette into the life, here's some of the common questions that I saw. What's the work-life balance like? Is it the same technology that we work on all the time? What's just the balance like generally? Office presence, what is that like? Is it all office, hybrid, remote? What's that? So in terms of, first of all, a general view of the work, different days for me often are different technologies. And I think that's very exciting. It keeps things very fresh. I get very excited to work on something different. And it all circles back because you're with the patent family for its life till it allows. So you're the one steering, taking care of it, looking over a strategy for it. And yeah, it's different all the time, but they come as your back and forth between the USPTO and yourself. So in terms of the areas that I work in, I am a cancer biologist. I did a lot of immuno-oncology. Cell signaling is in my wheelhouse. For sequencing technologies in my wheelhouse. Clinical diagnostics is one of the exciting pieces that's in my wheelhouse too. I'm a bench scientist, but I have medical family. I basically grew up in a laboratory. I kid you not, in the hospitals. And so I know a lot about the techniques in that. And so a lot of what I work on technology-wise has to do with diagnosis. The laboratory techniques are great. Like, you have so much information under your belt, from theory all the way to practice. All of that's valuable. The ability to data search, how to use data, how to program, doing literature dives, all of those things, understanding the sequences and how you would actually annotate that to provide something like a sequence listing. Those are all things that I do, and maybe all of them in a day, oftentimes, or sometimes it's a little bit lighter. I just do a couple of things. So for general work-life balance, okay, so I'm going to introduce the billable hours requirement here. this is very different for our basically who's on the bench, where you just pop into lab and then you're there until you're done. Law bills to every 6 minutes. It's very different. Keeping track of your time is very different. And billing requirements for different statuses, like whether you're tech advisor, patent agent, or associate, that's different from the firm. So if you're interested in looking that up for different firms that you maybe be interested in applying to, it's different everywhere. So what's true for one is not necessarily the same for another. There were some questions about geography in terms of, are you limited to where you can be? For bid law in particular, you're limited kind of, like you really should be somewhere where there's a real office, because law likes people to be in person as much as you can be. And other than that, if you're where an office is for your particular firm, you're in terms of travel, for where I'm now, I travel for the firm meeting that happens every year, and sometimes training, but I'm not required to travel. Like there's no portion of my job that requires me to be away from my family for an extended period of time, except my choice. Like an opportunity like this. So, okay. So the firm life is very client oriented. It's a service, right? It's like law is a service. They're service provider. If there are deadlines, we are working hard to make sure we make those deadlines. As a junior person in the firm, like the attorneys are my clients. So it's my role to keep us on top of the deadlines for the families that I handle. And that's true for anyone that's junior. In terms of whether, how many days in the office, I've always been hybrid in this role. I started up as 3 days in, and then, 2 days away. And when I started at doing Morris, I was supposed to be in the SD office of San Diego. But family circumstances kept me in Texas, so I was actually fully remote, but we did have a satellite office in Dallas, and I would pop into their companies to protect my own time, so I can really get stuff done. But yeah, through that one, I was basically fully remote because of the situation where I'm working primarily with people not in my physical office. So with Zoom, I talk to my people, over Zoom. These days, the firm is trying to go for 4 days, and that's true across a lot of large law firms. So, it's pretty typical across the industry. But there are firms that are fully remote. Totally depends. Like the opportunities, depending on what you're looking for, you can screen for them or screen them out. But a lot of them, they want FaceTime to train you. Like it's kind of the same as when you're in lab, you gotta get trained. And a great way to do that is in person. But yeah, consider, for that too, consider what will make you really successful, especially when you first start out. So right now I'm trying to protect my time and be in person and learn as much as I can so I can be efficient, and hit those billables. So typical workday, somebody did ask. I generally am available roughly 8 to about 8. And I put this out just to show you, I start off looking for correspondence or, emails from my attorneys. I'm looking at my docket, what's open, what do I need to take care of and send back out. And then I will work on all of my stuff. So whether that's applications or responses or preparing instruction letters for associates for, foreign prosecution or diligence tasks or taking meetings, all that happens in the normal workday. I work specifically for me, so circumstantially, I work mostly with a New York team. I'm based in DC. I work with New York and I work with San Diego. So I try to make myself available early in the morning through closing PST. So I just want to make sure that I'm around in case somebody needs something from me from either of those teams. That's my responsibility. So I do that. In terms of spillover time, if I don't get everything done, but there's a deadline that has to be done, I will do it. We'll make sure that we are hitting that deadline. But otherwise, I get to run my weekends too. Try to make sure I have some balance there. There's discretion built into the way that I've structured my day. And that's different for everybody. But generally speaking, I think if you have the project management skills, which you are learning as you are in your PhD roles or postdoc roles, you've got it. You can you can structure your time well and manage that. But yeah, so bottom line is being a patent agent, I'm finding it fabulously scientifically fulfilling, and it can be demanding. And it's, especially when you're starting out and you have zero experience, which many people starting out have zero experience. It's deep water, but the rewards for sticking it out, really, truly, like if you're going to go all the way up, it's limitless. The rewards are limitless. There are positions for and firms that do have routes for people that want to just be a patent agent and not go get a JD after your PhD. Some people don't want to do that. Perfectly fair. And often they will have better work-life balance because you're not doing the intern part of the job. So if you want to do that, that's a great career choice. And totally depends on what you want to do. I'm going to shout out Dr. Bethany Rorick, who's also a CEU Angie's alumna from HNGGP. She's also a patent agent. And the way that I was introduced to a boutique firm here was through her. She was working for a patent boutique before she transitioned to big law during the pandemic. So, all right, so practical advice. Some more common questions. What skills do you want to have, for IP? Like what will make you thrive? What's transferable? And honestly, everything you're learning, everything. I have a list of qualities that I've found to be very helpful to convey for people that are interested in this career path. You are driven by that pursuit of knowledge. You want to dive into new technologies. You know how. As a PhD, you can deep dive very quickly and then turn that back around to somebody at different levels and curate the way that you need to present that information. You know how to do that. Believe in yourself, you do. And even when it's outside your comfort zone, like we all can do that. Your ability to process very technical information, not everyone can do it. That attention to detail, very important. Being organized, deadline-driven, client-oriented, lots of creative thinking, especially when you're patent drafting. That's glorious to write, I find. It's very fulfilling. And yeah, let's see, all of that, yeah. Excellent communication skills, very critical. So, skills to develop that would be great and transferable. All of the data processing that you do, especially in today's age with AI and all of that is transferable. You still use those skills and need to be able to get to the nitty-gritty of those skills. Familiarity with your scientific databases, different ontologies, like these are all basics to any student in any of the disciplines here at Penn Shoots. And project management, all of that. Again, like you're in lab, all of those things are transferable. In terms of some actionables, really leaning into your network and finding good mentors and sponsors and people willing to talk to you, talk about you. That's how you're going to find these positions and find really good ones. And it's also true for client development for the future. Like if you want to become a patent attorney and be a partner someday, you really got to learn how to develop client relationships, nurture them, be in it for the long game. And that's something you can develop over time, and really think about your strengths and other skills that could make you market. How to pitch yourself. What makes you different than your peers, but also what are you good at that you can really talk about in those interviews. Make them excited about you. And your interview is going to be the best shot to do that. And then develop a sense of confidence. It's very important. When you present that confidence to the number of people that you will interview with for any firm, then they won't stop talking about you, but they'll want to hire you. So develop that confidence. You've earned it. Some of the questions before we do our Q&A, I got a lot of questions about AI. So the outlook for the career is still really good. I think it's going to make us more efficient, and I believe that many of the firms are believing that as well. Like clients are interested in the use of AI to cut down costs, but what that is really translated to is how to be more efficient. If you understand the framework in which to work with AI to be efficient and basically prompt manage your AI model, that whatever they're working with. There's certain LLMs that have come into use across different industries, law included. If you know how to feed it right, you know how to prompt it right, and prompt engineer correctly, and know how to verify, all the different data points that you're looking for and you're cross-checking. If you can do those things, which all of us do, especially coming from science in the modern day, that's great. You're going to be way more efficient than I think many people who had started back in the day. And really, it's just hand in hand. It's not that they're going to replace us. It's going to be hand in hand. And if you know how to use that, you know how to structure everything and understanding the framework, I think you're gold. And then how is the emergence of AI in impacting space for job opportunities? We're not being replaced. These are tools. They're still tools. They still need human oversight, and really engineering. You will not be replaced. Cool. Well, thank you for the time and for your curiosity. Connect with me. I'm happy to do informational interviews. And yeah, any more questions, I'm very happy to answer them. Yes.
I guess I was hoping to get a little more granular about your day to day. So like somebody hires Dwayne Morris to be their interface, and you get the application. Are you sussing out like, oh, we can patent this, we can't patent this, or are you just like, I know the right words and things to put on the application?
Both things. Both things. So the question was like more granularity about what our role is. Say if we have information disclosure from a scientist and they are taking us to prepare the application. We are looking at what is your invention, like us talking to you about what we think it really is, getting into the nitty-gritty of which details are important for it, talking to you about what eligibility looks like in view of the law now. The lawyers, of course, are providing that legal advice. I usually will sit on just as the subject matter expert, perhaps in your area, and asking you some of the detailed questions. Are there certain differences with, say, your composition that you're interested in turning into a kit, or the way that you're running like a flow-based assay, for example, or I don't know, you have a new cool tube that you've put interesting things into that people have not combined before. Trying to, like you said, suss out what's really there that's patentable and what we can protect. And then also, helping you strategize for where you want to prosecute that. Do you want to just do the US? Do you want it to be a PCT and get worldwide protection? Like, what are you looking at? And this is for, it applies across the board. If you're small, single person inventor, solo practitioner sort of thing, or if you're a small biotech company and you're looking for, you want to have a patent that you can to an investor and be like, hey, we have a patent pending. Fund us. Yeah, we did that. We talked to you about how to really strategize to grow. We do that as well. All sorts of things. But yes. Yeah.
You say that AI is not going to affect in terms of positions and what have you, but in this moment is it a reasonable market so that if you were considering to switch, are there going to be positions? Sort of like how there are no longer positions in files EIA.
So your question is really like whether there is less opportunity given that AI is more emergent,
or just even exclusively of AI, because the economy sort of is that going to then affect industry and then.
Or so I will say for positions like this and intellectual property, we're actually quite well insulated to changes with AI and its implementation and use in the industry. Again, a lot of that has to do with we're using it as tools for efficiency, really not to completely replace what a person with, say, my background can provide. Because yes, your LLMs may be fed with lots of, say, you can't do the entire thing of PubMed, for subject, but if say you feed it a bunch of stuff and you want to ask some questions, it will do that very efficiently, but I am still the last person to check whether the synthesis makes sense. And the synthesis parts and critical thinking are not there for the LLM. Like you are still providing structural framework overlay of how you want to dive into that data and pull out what you're needing to support physicians as you're doing private prosecution, for example. So really, in terms of physicians in the industry of law, I would not say that there's any reduction at the moment. And I don't foresee that being really the case. I think the people that will succeed and be really lucrative in the industry are those that understand how to be efficient with those tools along with that scientific expertise. I hope that makes sense.
Sort of a two-part question. Advice on like where to look for jobs in this field, and then also like I think I forgot my second question actually.
So the question has to do with where to look for positions. Kind of depends on which route you're going for. If you're going to look for technical advisors, right, because you haven't passed that more, because anyone knows that's good advantages. Look for tech advisor roles, tech specialist roles. You can look, LinkedIn has some. If you know names of certain firms, I would do that. Doing Morris is one. If you start looking for us, you look for others. Like, there's well-known ones like Finnegan, Cooley. There's many different firms out there. You can also just straight up look up, patent law firms, boutiques, intellectual property positions in big law. A good Google search, a well-engineered one will give you some pretty good ones. And then also, just be cognizant of what you're looking for in terms of your in-person availabilities and really look for the expertise that they're asking for. If you already hit 30% up because maybe you're the golden goose that they're looking for, and it's not necessarily stated. The people that are hiring are also subject matter experts. They will be pathogens as well, and they, as the people that are senior in there, they know what niche they need to fill. And reaching out to people at different levels even is helpful because, once you identify someone that will give you informational interview at any of these places, they'll get a sense of what do, and you can pitch, and hopefully that can work out for you. IPs, I feel like it's rather small in some ways, especially because for patent attorneys in the modern day, a lot of us are PhDs. There's that saying, it's easier to teach scientists the law than to do the reverse and try to teach science to a lawyer. Much more difficult. So, especially in biotech, pharma, they want you to have a PhD because they can train you. And they have programs to train you, including us. So, reaching out, even cold emails. I've fielded a number of them myself. Alumni networks too, also really good.
Yeah, I guess I remember my follow-up now is sort of like what's the timeline in terms of like someone close to finishing the PhD? Like, yes.
Now.
Yeah.
Talk to me now. Because you never know. And so currently I think where I'm at, we're looking for somebody that is already, like, we're looking, I think, for a lateral, somebody that's between the patent agent and partner. And that I know that we have some there. There's been some talk about it. If we can find one, that'd be amazing. But who knows, maybe we'll have a bigger load next year and we might want to hire another tech spec. You won't know unless you start poking around and asking people, tailoring, your materials. So now is great. And also for studying, I know your post-quals, but to get your hands on some of that material if you can. And yeah, I say that the NPEP is dry, but it does help to start looking at it. One of the things I told one of my mentees, Abe, who's in the cancer pilot program, is going to defend very soon. I'm so excited for him. Is to look at some patents from the university or look at some in your subject area and understand what the structure is. Like, have you looked at a patent before? Like, maybe you have, maybe you haven't, but like, what is in a claim? What is a claim? Like, where is that in looking at a patent specification? How does the summary differ from a scientific one that you're writing? Like, how does the language morph based on, which piece of writing you have to do? I think those are very helpful. And when you are able to verse that knowledge when you're doing informationals, that's even more helpful. It means to me that you've been looking into it and that you are continuing to be interested in cultivating ways to break in. And people are always willing to help, truly. So, sure.
So what's the difference between an expert witness, that kind of background, versus a technical advisor?
So I don't know from a legal standpoint, and I'm not qualified to provide a statement as such. From my personal understanding is that they would be one and the same in terms of their expertise, but usually, at least from what I've seen, expert witnesses tend to be much more senior in their career and have gone that route. But you're still a subject matter expert in what you've studied. So you can fully hold yourself out as a subject matter expert in something from having a PhD.
Yeah, certainly you just became an agent. But are you eventually considering the JD route? Or
I sure am. Yeah, no, I am. I think for a while there, I was like, maybe 80%. Just looking at how happy I am right now with like feeling that it's fulfilling that science brain of mine and making use of some of the things that make me really good at what I do that are away from the bench, which I also loved, but burnt out from. I'm still able to feed that part of my brain and myself. And yeah, I think I would really love to do that. And like I said, there are many of the big firms have programs that will cultivate you all the way through. So I'm lucky that I'm in one that does, and with mentors that really make me feel like they care a lot about my career progression. So. Yes.
Would you recommend, I guess it depends, it's probably the answer, but like being like a tech spec first and then like kind of getting some experience and then taking the patent bar, or like just big patent bar before being a tech spec and then being a patent agent right away?
So I did the former, and for in case the audience didn't hear it on the slides, the question has to do with whether the timing for taking the patent bar should be before or after your test. I did it, as while I was practicing as a tech spec, and I will say, timing wise, it's hard because you're also learning and trying to make billable hours and like understand all of that. However, you do have resource available to you, and that the mentors are also there to talk to you through questions and understanding the logic and the statutes and the way that the law has changed over time, which is the perspective that's very helpful. So, I mean, I'm a little bit biased towards doing it contemporaneously, but you can certainly do it the other way around too. Like, say you're in a postdoc position, or you're in industry and you're thinking you want to pivot, like, certainly doesn't hurt to just start studying, because it is going to take time to understand the lingo, language, and the concepts for how you do patent practice. So it certainly doesn't hurt. Yeah.
I was just curious about like the range of topics that you like cases you look at around your expertise. Would you say it's like primarily focused in like cancer biology, or just like anything within the realm of science, or like a little more?
So it's more the latter. Like I think I threw it on my slide. So yes, I'm a cancer biologist. So a lot of stuff I have is within some of cancer, like in terms of cell signaling stuff, or how to look at biomarkers in specific cancers or compare them. But I also do a lot of like immunology or like techniques based applications as well. So anything within the broad umbrella of my broad expertise, I have probably already touched. Everything that I've listed, I have matters in all of those and more.
Then would you say that your firm, like, because you have the PhD background in science, they feel confident in that, or
Yes. Oh, yes, but that's, they have to train you for the law part and how to craft, to be able to protect an invention and how to structure things so that the language is fully supporting what you're trying to protect. So that you learn to craft, and you learn that as a practice. But in terms of the confidence in what I know, they definitely trust that I know my stuff. And you demonstrate that because they will ask you hard questions about, pieces that they might not understand, especially like, for example, one of my mentors did a lot of stuff with histones and epigenetics. That's not my area, but we can still talk about that back and forth about some of the things that crosstalk and what applies from her, studies ages ago to what I have done techniques wise now that work for a specific application that we're working on. So yes, yeah. And be confident in your own skills. Like, a lot.
I've got two. Sorry, I was letting you guys get in there. So before you became a tech spec, you worked in industry, in science. So I'd be curious if you felt like having industry experience was helpful in making you competitive for that first position, or put another way, if you think someone who is either transitioning from the PhD or from the postdoctoral into maybe, let's say, a tech spec position, is that feasible? And then I have a related question. When you got that first tech spec role, what do you think helped you get in the door? Like, what on your resume made them interview you? What in the interview did you make them hire?
Okay, so I'll go with your first question that had to do with whether the postgraduate experience that I have had maybe made me yes or no more competitive in securing my current role. I would say it was helpful, but it was definitely not necessarily a hard line. It, for me, in my perspective, it added to my skill set. It just happened to add more. It's like I have a little bit more. But I also knew from being in industry, that specific industry, that I didn't want to be there anymore because I was bored. That said, I could then really talk about, I know that I wanted to be in patent law. Like, I can tell from that experience where it was a pretty good idea when I was in grad school. Now I read that really is it. And that's kind of what I'm saying to the other point is, if there are ways that you can discuss and really understand for yourself and coming to a decision about where you want to go career-wise, what differentiates something like this role in IP versus something like an MSL or a different, in data science or whatever, that contrast, it has to come out, and it will get asked because, if you're a firm and you're going to train people that you're going to hire and want them to go all the way through to the terminal part, if you're going to spend all of that time, do you want them to not be sure that they really want to, go as far as they can with this? Show that passion and really come down to what makes you happy in your, what skills make you happy and make you fulfilled. And if that aligns with a career like this, then you can speak to that. And that really, I think that really helps. To your second question, so which pieces of my background made me competitive? I have a very broad expertise, I will say, partly by luck, partly by design, which is great. Just having a PhD, though, broadly, and being able to really, really beautifully share effectively, like your effective communication about what it is whether it's a technique or it's a particular protein or anything that you can really have a beautiful pitch for that very well and are confident in showcasing that as you're doing interviews. I think that's what really shines. And the other part, if you go into this route and start interviewing, I think you'll come to realize that, people are also looking for a good fit. Every team's going to be different. Every firm's going to be different. Each place has a different feel, and the people that are interviewing you are getting a feel for you as much as you are getting a feel for them. And you want to make sure that you gel with that team, have the values that are reflected in the way that they talk to you, and vice versa. And if it happens to be a great fit, that's going to come together. So I hope that answers your question. Yes.
How much do you recommend? Like, we all have our expertise. We all have our areas where we are the subject matter experts. But then we have our areas where we're not. How valuable is it? Like, I don't know mass spec. But if I wanted to go into this field, like, would I need, or how much would you recommend that I start learning as much as I can about those techniques and areas where I'm not necessarily an expert?
Sure. So I would say, if you're right, if you already are an expert in something, so as a PhD, you already are. If you are looking to have a new technique under your belt, I think you should go for it. But if you don't be afraid to say that's not your technology area. If it's something that also you're not interested in, why would you bother?
That's what I was wondering.
So, in terms of looking for what fit is, when you read descriptions for what they're looking for, what techniques they might, and ask too, either in informationals or during interviews, like what are the technology areas? What are the different techniques that are valuable? Like, and see if that aligns. If it aligns, that team's probably already going to want you anyway. If it doesn't, then you go for the next opportunity where you fit better. It really should work with who you are at where you're coming from. And that said, you don't have to have experience in everything. Certainly not. Just be confident in what you do know. And also, as we all know, be willing to say that you don't know if you don't. Don't BS it. Never do that. So, yeah.
So obviously in graduate school, right, we have our peers, we talk to each other, we have conferences that we go to. In like this particular role, you mentioned you go to firm meetings and trainings, but are there other external opportunities you get to talk to your colleagues so that you're up to date on what's happening? Or like if you have like a personal favorite podcast or whatever, like you get biotech news from or something.
Sure, yeah. So there, in terms of keeping up to date with what's going on, there are a number of different like newsletters, which I can try and circle back to you on if you email me, that kind of show what's going on in terms of cases that are, before the federal circuit or before the Supreme Court, or there's also IP Watchdog is a blog where you can learn a lot from. There's some IP related podcasts that you can look for. I don't think I've really gone to the podcasts. I have read a little bit of the blogs out there, and a lot of the firms actually publish a lot about the state of things, and how technologies are being protected versus, how the laws are changing for certain things that you want to protect. And as for like conferences and stuff, like it varies from firm to firm. I think I think we're allowed to get coverage for at least 2 different memberships. I know my AACR is still current as of when I last checked it, so it's current for this year, I think. So they haven't, for example, paid for that one, but for American Intellectual Property Law Association, AIPLA, that membership is one that is useful, and that's covered as well. So that's a really good resource as well. And you can look also, if you're interested in jurisdictions abroad, you can also look up for publications abroad. But yeah, like if I wanted to go to a conference and I have a really good business reason to do so, it's worth talking about, and they openly will encourage you to talk about and make a case. That's what there's a marketing initiative request for that. So the worst they can say is no. So ask. If you don't ask, you don't get. Yes.
I want to say thank you for presenting this. You seem very enthusiastic about your work. I was wondering like specifically, because I'm not of this scope, like what is it in like task wise you run this work that makes you feel enthusiastic about it? Like what is something that you're excited to do while you're doing this?
Sure. I personally really like the diligence tasks where I'm doing a lot of analysis of like, what's the state of the art, the state of the art for a particular device or a technique or something, and like doing that deep dive and really getting into the details of like what's out there and what is open to development in terms of invention and innovation. Like I think that's really cool. I get really excited about tasks. I also really like drafting applications that are in my area because you won't get them all the time. But when they are in your area and it's like a technique you really know, it's super exciting to just like throw all your knowledge in it and then put, you get to like, you're helping the inventors with that invention cover more. What are other ways that we can round out the scope of protection? Looking forward to like, what would the next step be that we could also cover? Like, have they thought about this? Like, because I know the technique, I know that there's something here that we can also add that would maybe be cool. For example, I've done that with a cannabis app, I believe. I'm trying to remember the set of compounds within the plants, but adding some features that they hadn't thought about, and they were like, "Oh, that's really cool. Where did you get that from?" And I was like, I do a lot of planting and I do a lot of, all sorts of stuff. So and that's true in the molecular biology portion too. Like, we have a lot of techniques under our belt. We know them from theory to practice and how to troubleshoot and what would an addition be that would be helpful. And I find that exciting. So it's really, some is the breadth of subject matter, being able to still be at truly what is the cutting edge, because these are new things that people are trying to like put out there and protect. I find that very exciting and very fun to get to talk to some of the scientists. If you get the chance to FaceTime, get FaceTime along with your partners with the clients, and they get to introduce you as this is the expert we have on this, so they're going to sit in on the call. Let's talk about your stuff and what you want to do with it. It's really fun. It's really, really cool. Thanks for the question. If there are any more questions, please email me. Also, please connect with me. I'm happy to connect with you. Thank you.